So Komal, can you tell us what is a charge and when is it required to be created?
Okay. Um, the way I have planned to deal with this webinar is that we will be dealing with things as concepts. We'll be trying to understand, various aspects of concepts of the things. And once you understand the concept of something, then it becomes very easy for you to understand why a particular legislation was created around it and what is the logic behind a specific provision that was made around it. So the first thing that you would do is, to try to understand the concept. So when we are talking about what is a charge, this is defined in section 216 of the Companies Act 2013, and it states that charge, the definition refers to creating interest or a lien on a property as a security, and it also states that it includes mortgage. So what basically should be involved here is that there has to be a borrower and a lender, because the definition talks of having the property as a security. So that security is for the repayment of a loan. So there has to be a borrower, there has to be a lender, there has to be property involved, and there has to be some kind of interest or lien which is created on that property in order to constitute a charge. So these elements, if we keep in mind when we are talking about whether something amounts to creating a charge or doesn't amount to creating a charge, then we will be able to look at each of the elements. Are we able to tick off each of the elements? Then it amounts to creating the charge. If we are not, then it doesn't amount to creating a charge under the Companies Act, whatever the transaction may be. So the four things to repeat once again is there has to be a borrower, a lender, some kind of property involved which is given as a security, and an interest or a lien which is created on that property in order to constitute a charge. Okay, so these four things are necessary. I guess it's seven
Okay.
only just now. Yeah. So yeah, so for the viewers who have just joined us, I'll repeat the four things that are there, which are necessary in order to constitute a charge under the Companies Act, and that is there has to be a borrower, there has to be a lender, there has to be property involved which is given as some kind of security, and there has to be an interest or a lien created on that property. So what happens then is what's interest? Interest is some kind of rights which are created on that property. What is lien? Lien is usually when the lender retains possession of the property while providing the loan. So these are the two things which are there. To answer the second question, when are charges required to be created, this is also dealt with similarly in the definition of the charge. So there has to be a lending transaction. Obviously, there has to be an agreement between a borrower, which will usually be a corporate, and a lender, which will usually be a bank or a financial institution. And in this case, the bank or the financial institution and the corporate will have negotiated the terms. They will have discussed the terms of the lending arrangement which is going to take place, and based on that terms, they will also have agreed the property of the corporate which would be provided as a security. So once these discussions have taken place, once there is a lending arrangement or a transaction which is in place, we can say that this is when a charge is required to be created. That means the company will have to charge its property, will have to register that charge on the property. So it sort of amounts to making a declaration that this property is now charged in favor of a particular lender, and after that there will be the disbursement of the loan. This can be based in phases, this can be all at once, depending upon what are the negotiations that have taken place between the company. We may have a question here, and I might add on this. Okay. Yeah, so if any of the viewers have any questions related to this, one two five one seven seven. That's 9167 if there are any questions pertaining to the discussion that we have. Yeah, so moving forward to when the charge is required to be created. So when these discussions have taken place, this property will be charged in favor of the lender and the disbursement of the particular loan will take place. So the stage after when the negotiations have been completed between the company and the lender, which is a bank or a financial institution usually, uh, that's the stage when a charge will require to be created, and this will be before the disbursement of the loan. Okay, can we move to the next question, Parth?
Okay, Komal, how are different charges created by the company? Like, what is the process?
I think I already briefly touched upon the process here as to how the charges are created. There are discussions between banks and financial institutions and the corporate who is borrowing a specific amount. Um, so that's basically. But what happens when the charge is created is there will be an agreement or an instrument which is entered into between the bank and the financial institution. Now, this instrument can be a lot of different things. It can be a deed of hypothecation. It can be a mortgage deed. It can be, simply a loan agreement in some cases. But it will be any kind of agreement which basically states down the terms which have been agreed between the bank and financial institution and the corporate about providing the loan and about the property which is included as a security and of registering or creating a charge on that property. So that instrument, the fact of the instrument having been entered into, that is when that's your date of creation of charge, which you put when you file your charges with the registrar of companies. The date of the instrument when both the parties have agreed onto the particular term, that's your date of creation of charge. So briefly, that's the process. There will be negotiation between the borrower and the lender. Borrower, who is a corporate usually, lender, who is a bank and financial institution. There will be an agreement which is entered into between them, which will state the terms of the loan and also the terms and details of the property which is provided as security to create the charge. And that is what will be filed or declared with the registrar. That is briefly uh, the how a charge will be created. And when I deal with different types of charges, the different types of charges were usually used to be listed in the Companies Act 1956. It had a list of different kinds of charges, like charge on the uncalled capital, charge on book debts, charge on ship or share in ship, and floating charge over the assets of the company. It had a list of charges, which was in section 125 of the Companies Act 1956. But if you look at the Companies Act 2013, then the definition 216 simply states that any kind of arrangement which will create an interest or a lien on the property which is provided as a security and which includes mortgage. So it's a much broader term under the Companies Act 2013 while creating the charges. So that is basically dealing with different types of charges. If we move on to the second part of the question, Path, can you repeat what was the second?
Yes,
Second.
Komal, does giving a corporate guarantee amount to creating a charge?
Okay, let's deal with that. Corporate. Let's try to understand again from a concept basis. What is a guarantee? A guarantee is simply someone saying that in case the borrower who is borrowing the money doesn't repay the money, then I will repay the money. That's what it is. Like the guarantor will step in the shoes of the borrower in the event that the borrower defaults to repay the money, and the guarantor will agree to repay the amount to the lender. So in this transaction, we have to consider what is happening between the lender and the guarantor rather than the lender and the borrower. In the case of a lender and a borrower, there may be security involved, but when we are talking about the lender and the guarantor, this transaction between the lender and the guarantor, there is no property involved in it. It is simply an assurance by the guarantor that he will step in and repay the amount in the event that the principal debtor, as how it's termed in the Contract Act, or the principal borrower fails to repay. So, as between the lender and the guarantor, there is no security involved. There is no property involved which the guarantor is, providing in favor of the lender. So as between them, if we look at it, that element which of charge which says that there has to be a property and there has to be a security, that is the missing element in this case. So that is why this providing of a guarantee doesn't amount to creating a charge. And if there is a corporate guarantee which is provided by one company in favor of a loan, in favor of a lender, for a loan which is taken by another company, this transaction will not amount to creating a charge. There may be a charge created in the case of the principal debtor, the main company who is borrowing, if they are providing assets as security. But as against the company which is providing a corporate guarantee, this will not amount to creating a charge. Usually corporate guarantees will be provided as collaterals. They will be provided in addition to the security which is provided by the original borrowing company. It will not be a solo transaction. Usually it will not be the case that the principal debtor is taking an unsecured loan and another corporate is providing a corporate guarantee for that loan. Usually this will not be the case. So it will usually be provided as a collateral for an original loan which is there in favor of the principal debtor. So and this happens because mostly in group companies, corporate guarantees will mostly take place in the case of group companies. Imagine that there's a flagship company in place and that has an already established relationship with the banks or financial institutions who are going to be the lenders. Now there is a subsidiary entity in place which is created for a specific project. So the bank and the financial institution will be lending money to this subsidiary for dealing with the project, and the bank or the financial institution will not have an already established relationship with this subsidiary entity. So just for additional assurance, they will request a corporate guarantee from the flagship or the operating entity with which they already have an established relationship. So, okay. And that will sort of, give them an additional assurance that will also help them to understand that there is, or confirm that there is a relationship between the flagship entity, which is operative, which they know is in a good financial position or whatever, and the subsidiary entity, which may be a relatively new entity created for project purposes. So this is usually when corporate guarantees are used, and they do not amount to creating the charge.
Okay. Okay, Komal, can a charge be created in unsecured loan transactions?
Okay. So we saw that one of the main elements of charge is a security. We saw that there has to be a property which is involved in a charge. There has to be an interest or lien created on that property. So unsecured loan by definition is a transaction where there is no security that is provided. Usually these are like, personal loans, your personal loans, how your bank provides you personal loans for certain purposes, because they, on the basis of your ability to repay or on the basis of, your salary slips or whatever, they understand that you are going to be able to, they predict sort of that you are going to be able to repay that particular loan. So therefore there is no security which is created. That doesn't mean that the lender doesn't have any kind of right. Like the lender can definitely go to court and enforce the repayment of the loan, but there is no property which is involved in the unsecured loan. So the lender is not going to be able to, claim his right on any kind of property of the borrower and sell it in the event that the borrower fails to repay the loan. It is just a loan which is given without any kind of security. So the element of the charge which says that there has to be a security and a property involved, that is missing in case of an unsecured loan. Therefore, it doesn't amount to creating a charge.
Okay, Komal. What happens in the case of power of attorney? Can we create a charge through power of attorney?
Okay. Uh, Yeah, this is interesting because power of attorneys are usually would be given to someone to enable them to deal with a particular property. Let's say you are you have bought a property, or you are in the middle of a transaction where you are purchasing a property, or have purchased a property or something, and you are not going to be at the place where that property is created. So what would you do? You would give a power of attorney to somebody to be able to deal with the property, say, and to say, like, you have a power of attorney to go look for tenants for this property, to enter into, like, manage tenancy deeds and all of this kind of things. This is, so you would sort of give an authority to somebody to make specific dealings with that property, right? You will enable them to have to do specific acts with that kind of property. That's what a power of attorney document will do. It will give you a power to do specific acts in relation to the property. So in this case, there is property involved, but what is missing? A borrower, a lender. There is no loan transaction, and the property is not given as a security. Like, it is owned by somebody, and only a specific power to deal with that property is given by the owner to whoever is the attorney holder, whoever is the POA holder. So in this case, that element of a loan transaction, a borrower and a lender, this is missing. It is just a right or a power given to somebody to make specific dealings with the property. Therefore, power of attorney also doesn't amount to creating a charge on the property, and it will not be like, the power of attorney will not be registered with the registrar as a document creating a charge.
Okay, Komal, earlier you talked about floating and fixed charge. Can you tell us about the difference between both, and when are these charges created?
Yeah, sure. So fixed charge is usually created when the security which is involved in the charge is fixed or crystallized. Let us say the company has a particular plant and machinery, and then that is charged to the lender as that identified. It is identified that this plant and machinery, which is lying in the company's factory at this place, this is given as security to the lender. This is a fixed charge because that property is specifically identified, and the description of it is laid down wherever in the document. What's a floating charge? Floating charge is where that property is not fixed. So when you can say that there is a charge which is created over the present and the future stock of the company, like, this is not a fixed charge, because the stock of the company keeps on changing at different points of time. The company will have different inventory at different points of time. And when we are also talking about present and future, you don't know what kind of stock the company is going to get in the future. So it's a floating, or it sort of hovers over, whatever is the property that is charged. Another example of a floating charge, and this is very debated, is a charge on the book debts of the company. If someone creates a charge on the book debts, means on a particular day, if I have this much debts, this is what I give to you as a security for whatever loan you might give me. And this is very tricky because debts, it's a very contentious thing. Like, someone who is going to realize those debts, who is going to collect the money from those debts. So when someone says that there is a charge which is created on the present and future book debts of a particular company, then that question arises that who is going to manage the collection mechanism for those debts to be able to enable the company to repay the loan. or to enable the lender rather to create or to lay his claim on that particular amount. So that's another contentious floating charge issue. And then when we talk about floating charge, we talk about crystallization of the floating charge. When does it crystallize? So what happens, what is crystallization basically is that the floating charge is converted into a fixed charge. So when at a particular point of time, the company is not repaying the money, it has defaulted in the repayment, and the lender sort of, has reminded or given notice to repay the money in many cases, and it doesn't happen, then the lender can say that okay, the charge now crystallizes. That means that whatever your stock is in place right now, I have a claim on it and it is fixed as on that date. So whatever is the value of the stock on that particular date, that is the amount which the lender will lay claim to be able to get his money back. One thing which I would like to note here is that when you look from the lender's point of view, the lender is actually as much interested in your ability to repay the money as he is interested in the security which is which is provided. So when the bank or the financial institution are considering granting a loan, they will look at the company's profitability, they will look at the company's ability to repay the money more or maybe equally as much as the security which is being provided for creating a charge. So when you're looking at what is better from a lender's point of view, a fixed charge or a floating charge, the first thing actually that is important from the lender's point of view is the ability of the company to repay the loan. Okay. The second thing, when you're looking at the property that is created, whether fixed is better, floating is better, this depends on the circumstances. Because if you say fixed, someone might say that, if it's a fixed property, somebody will know that, okay, this is the value of the property and therefore a fixed charge might be better. But what happens in that case is that tomorrow that value can be depreciated to an extent you wouldn't even imagine. It may be a fixed property, it may be a plant and machinery, which is let us say provided to the lender as a security. But tomorrow there is a new kind of invention which makes that plant and machinery obsolete, and then you would have no value of that plant and machinery. Similarly, stock. What is the inventory which is in question with the company, or a floating charge? What is the amount of what is the type of security that is provided as floating charge? If you look at the stock of the company, in cases of some companies, the stock may be very high value, like jewelry. In some cases, the stock may be of not much value, like clothes. So that depends on what kind of transaction is being entered into, what is the amount of the loan, and depending upon that, it will be decided which kind of security is better, fixed or floating charge, what kind of charge is better, and this all will happen much before actually the charge is created, between when the negotiations are happening between the company and the bank or financial institution who is lending the money. From the company's point of view also, like when you're talking about fixed or a floating charge, fixed charge for that matter might be a better option from the company's point of view, because they have an identified asset which is locked or provided as a charge. Stock, if stock is provided as a charge, then the company might have a question at some point of time when the charge crystallizes, there can be excessive stock with the company at that particular point of time. So when that charge is created over a present and the future stock of the company, the fixed might turn out to be better option in case of companies. But again, this depends on the negotiations or the agreement that has happened into between the bank and the financial institution before the charge is actually created.
Okay, Komal. One question I wanted to ask is registration of charges mandatory? And if yes, and why should we should register charges? And what are the benefits for the company and the lender for registering a charge?
Okay. Again, if you look at the logic behind why should charges be registered in the first place? Why can't this be, and a transaction just between the borrower and the lender? There's a loan that's given. There is a property that is provided as security. Transaction over. Why do you need to declare it? So the need to declare it is because there can be other lenders who are going to be in place after a particular lender has lent some money to the company. There can be other banks, there can be other institutions who are also lending to the company after that particular property has been charged. What happens then is that if there is no declaration or no registration, the same property will be provided as a charge by the company to the another lender, and they won't even know that there's already an existing charge on that property. So this is the logic why the registration requirement is put into place, so that the company has to make a declaration to the registrar and file the details of the property which is on which the charge is created, so that when some another lender is considering lending to the company, they will go and make a search into the register of charges, and they'll check if that property which the company is proposing to provide as a security is already charged in favor of another lender. Um, this will enable them to improve the negotiations. It's not that the future lender will simply refuse if the property is charged to another lender, but then they say that this is a second and a subsequent charge which is created on that same property. Therefore, the terms may be negotiated in that manner. They'll say that the first lender in whose favor that charge is created, again, if they may be happy to give same rights to the first lender, they may not be happy to give same rights. If they are happy, then that means that there are pari passu rights which are created on the property in favor of both the lenders. And what will happen in that case is the first agreement, there will be a modification which is filed. For the second charge which is created, there will be a creation document which is filed. So this is the logic or the reason why that registration requirement is put into place. Yes, registration is mandatory for a company which is creating a charge. It is required by section 77 of the Companies Act, and if you do not comply with this registration requirement, there is a penalty which is provided by section 86, which is for the company as well as for the officers of the company who are in default. And this ranges from 1 lakh to 10 lakhs for the company, and then for the officers I think it is from 25,000 to 1 lakh. So that is that's that's the requirement for the company to register the charges. From the lender's point of view, registration of course is mandatory, because section 77 further states that when a charge is not registered, it will be void against the liquidator and it will be void against another creditor of the company. That means that the liquidator will treat that loan which was given by the lender as an unsecured loan in the event of winding up of the company, if the charge is not registered. Secondly, the another creditor who lends to the company after the first lending has happened, they will take precedence. If that charge is registered, if the second charge is registered while the first one has not been, the second charge will take precedence on repayment over the first charge which was not registered. So for a lender, it is an ultimate requirement that the charge should be registered. And this is the reason why section 78 enables the lender to go ahead and register the charge when the company has failed to do that. So when the company has failed to register the charge, the lender can proceed to require the company to register the charge. Okay, and the registrar will send a notice to the company for on saying that there's a request to register this charge, and that will be, I think the period is for some 14 days. And then if there is no response from the company, the lender can go ahead and register that charge.
Okay. Komal, what is creation, modification, and satisfaction of charge?
Okay, creation we just dealt with is that when the original transaction of lending happens and when the property is first charged in favor of a lender, that's when the charge is created. When the deed or the instrument which is creating the charge is entered into between the company and the lender, that's when the charge is created. What is modification? Modification is when there is any of the terms of the loan agreement or any of the terms which were agreed upon for creating the property as a charge are modified. Let's say, for example, the rate of interest on the loan is modified. Let's say, for example, there is some change. There are some changes in the property. So when any kind of modification in the terms on which the charge is created, then that amounts to a modification and that needs to be filed with the registrar as well. For the similar reason why creation was required to be filed is that subsequent lenders will come to know what are the new terms which somebody else has agreed with the company for that creation of the charge. What is satisfaction of the charge? Satisfaction is when that loan is repaid in full and the property of the company which was charged is now free of charge. That's when the charge is said to have been satisfied. And what is specific in terms of satisfaction is that there are only 30 days given to file a satisfaction of charge. In case of creation and modification, if you are not filing the charge within 30 days, then the registrar has that discretion to extend it to 300 days within which you will file the creation or modification. But in terms of satisfaction, if you don't file the document for satisfaction of the charge within 30 days, then you straight have to go to the central government and ask for an extension of time on when you are going to file the satisfaction. There are exemptions which are given to specified IFSC public companies or private companies. I think for them that term is 300 days. I would have to cross check, but my belief is that for those companies the term is 300 days. But for other companies it's 30 days, and otherwise you have to go to the central government for extension. For creation and modification, it is 30 days. Then you go to the registrar for extension up to 300 days. Then you go to the central government for extension beyond 300 days. But for satisfaction, it's 30 days and straight away, a request for extension to the central government. Earlier, this used to be the company law board, but now that's not there, and there is NCLT in place of company law board. But then this has not been placed, I think, in the NCLT domain. It straight goes to the central government now.
Okay. Komal, what are the different type of documents that are required to create a charge, and what care should be taken while you are drafting or reviewing these documents?
Okay. In most of the cases, I have to say from my experience that you are not going to be able to draft the documents, because these terms or the documents will be dominated by the bank or the financial institution who is giving you the money. They will usually have set templates for everything. The legal department will have set agreements for all different types of charges or transactions which are created, which is why you need to be extra careful on those documents, because usually it will be used as a template. So you have to cross check everything that is included within that document, whether the property is properly stated, whether the amount is properly stated, whether the terms are properly stated in the document. Basically anything and everything that you would put into your charge 1, which is the form which is filed for creation or modification of charge. Anything that you would put into that charge 1, you have to cross check or double check in detail in the document. So basically, if I deal with the different types of document, there will be a deed of hypothecation in case there is a hypothecation. Now, hypothecation, what is it? It's like how your car loan works. So money is provided to you. That particular movable asset is charged in favor of the lender, but you still get to keep the benefit or use of the asset. What's mortgage? A mortgage deed can be used when there is there is a transaction when the property of the company is charged as a mortgage, and this is like your home loan. So like the lender will be providing money to you. You will be giving the title deeds generally of your property to the lender, and that once the repayment happens, then that property will be released. But in both the cases, like if the repayment is not made, then the lender has the rights to foreclose or take the property into their possession.
Okay.
So basic two main types. There can be loan agreements when the charges are created on book debts, or the interesting thing, if you look at charge one, there is also a charge on uncalled share capital of the company. I'm not come across any, I'm yet to come across any instance where a charge was created on the uncalled share capital of the company, but it's still there. If you look at charge one, that's one of the options or types which you would be filing if there is a charge created.
Okay, Komal, what are the documents which a company is required to maintain in relation to charges?
Yeah, so there is a register of charges which the company is required to maintain, and this will include all the details of the charges that the company has created in its history. This is a live document, like you are supposed to maintain the register of charges forever. There is no time limit up to which you have to maintain that document, and after which you're supposed to not to maintain. It's a lifetime document, like how your members register is there. It's a statutory register, so that has to be include details of whatever charges are created by the company over the life. It has to bear the details of when these were created. It has to bear the details of the lender. It has to bear the details of the property which were charged in favor of the lender, and then if it was modified, when it was modified, and if it was satisfied, when it was satisfied. Then again, the company is also required to keep the instruments, the copies of the instruments which create the charges, and these are required to be kept for a period of 8 years. Uh, and both of these have to be kept open for inspection by any member or creditor of the company. So when does this document come really useful? When somebody is planning to make an investment into the company. Okay, when there is an investor who is looking at different kinds of documents which the registers which the company has maintained, he will definitely be interested that what extent of the property is given as a security to a lender. What is the amount of the borrowing by the company? And then that cross check will extend to whether that borrowing was permitted or sanctioned by the board of directors by a resolution, whether that borrowing was within the limits, and or anything that is related to whatever are the details which are included in the register of charges. This is when it is important that when somebody is looking to buy the company, and they are looking at various documents which the company has maintained. So the register of charges needs to be maintained for a lifetime. The instruments by which the charges are created or modified need to be maintained for a period of 8 years. And again, this section is in a blanket penalty of the penalizing section. So if you're not maintaining the registration of the register of charges, it is the same penalty as if you are not filing the charges with the registrar of companies, because that section speaks anything that is a requirement under that particular chapter which deals with charges.
Okay, Komal, is there anything different in relation to the charges created by a company outside India?
Yes. So when you are dealing with charges outside India, there can be two things. Either the property which is creating a charge is located outside India. So in this case, there has to be a proper description of the property which is creating the charge. And the interesting thing or the different thing is that the instrument by which this charge is created, when you are submitting or filing this charge with the registrar, the instrument by which this charge is created where property outside of India is involved, this needs to be certified by the officials of the charge holder, which is the lender. So they need to confirm that that's the document which is creating the charge when the charge one is filed with the registrar of companies. While in the case of a property which is situated within India, it could be any official of the borrowing company or authorized official of the lender. So this is one thing. When there's property that is outside India, it is the charge holder or the lender's officials who are going to have to certify the copies of that document. The other thing that can happen in terms of properties outside India is that the lender is outside India. So either the property can be outside India or the lender can be outside India. When the lender is outside India, this falls in the category of an external commercial borrowing. So whatever are the RBI regulations that are applicable to an external commercial borrowing, there has to be eligibility of the company to be taking an external commercial borrowing. There has to be lenders who are recognized to be providing an ECB. And there have to be norms for maturity and everything which are applicable under the guidelines of the Reserve Bank of India, which apply to external commercial borrowings. So in this case, those guidelines will become applicable and they will have to be followed in addition to the requirements under the Companies Act. The company itself cannot be outside India when we are talking about charges under the Companies Act, because the company as defined in the Companies Act itself is a company formed and registered in India. So either of the two factors, either the property can be outside India or the lender can be outside India. The company has to be in India for registration of the charges in India. That's by far, I believe, the only typical thing which is different from from charges which are created in India. I would like to deal with some typical questions which may come across when you are dealing with charges. Like what happens to the charges in the cases of an amalgamation or merger of entities? Okay, so all the property of the merging entity is transferred to the remaining, the merged entity. So what happens to the charges which are filed in the name of the entity which is being merged? There'll be charges which are filed by the banks or the financial institutions with the registrar of companies, which say that ABC Limited is a borrower, and then ABC Limited ceases to exist at all. Then what happens? So in this case, what happens is that when the merger is taking place, obviously the merged entity or the investor in the case of a takeover, and they will be looking at whatever are the contracts or the agreements which the company has entered into. So they will look at all the instruments which have been entered into by the company which is creating the charge. They will look at what are the pending charges, and then there will be a reworking of the contracts. So maybe fresh contracts are entered into with the new lender, which will say that all the obligations or liabilities of the merged entity are now actually the obligations or liabilities of the new entity, which is the result of the merger or amalgamation. And because the property itself, which is subject to charges, itself transferred to the new entity. So in this case, my take on it is that it will not actually be a modification. There will be two transactions. There will be satisfaction of all of the charges of the merging entity, because it is going to cease to exist. And there will be creation of charges, fresh creation of charges in favor of the merged entity, because that is the entity which will be now taking over all of the property as well as all of the liabilities to repay the particular loan. So this is one typical element or aspect which I wanted to deal with in respect of charges. If anyone has any questions, I think they can put on WhatsApp to me on 9167 125 177. That's 9167 125 177. We'll wait for a few minutes unless Parth has any further questions on this topic. No, I think we can.
Yeah.
We can just wait.
Okay. No questions. Okay. Thank you, Komal. Thank you, everyone, for joining us today. I hope everybody got to learn more about charges under the Companies Act. And yeah, so let's wrap up this session then.